Good morning. My name is Kathy Kokas. I am with Washington PTAC. I oversee the Kitsap Economic Development Alliance Subcenter. We cover the Kitsap and Olympic Peninsulas, and of course, also work with any other clients specifically that are wanting to do business with the Navy. We're excited to bring this new class to you today that Terry has created for us. Terry is a volunteer for us and has great classes, great experience, and he's ready to assist you. So with that, Terry, take it away.
Good morning. Long-awaited new class on contract modifications. So much of what we do is get contractors ready, get registered, and get ready to compete for award of contracts. But I just felt that there was a need for, okay, now you got a contract and you're most likely going to get a modification. So how do we deal with that? So I've created a class to enlighten people on the contract modification process. So has everyone received a copy of the PowerPoint and the one-page handout, table of clauses? I see one hand, fingers up. Anybody not receive it? Okay, good. That's for your use in the future. Take your notes on there today. And as I provided a lot of reference sources in the PowerPoint presentation, so you can always go back to this, look and find the page where we had the discussion on your topic of interest, and you find a place, the source in the Federal Acquisition Regulation where you can learn about the details of it. So the goal for this class is for you to become aware of the various types of contract modifications and get familiar with terminology. There aren't very many pages to the presentation, but each page is impactful and we may have much discussion on the subjects. You can ask your questions throughout the class or jot your questions down for the end of the class, and I'll address all of your questions today. So any questions before we get started? Okay, I have one. Actually, I have two. So there's one there now. How many types of contract modifications are there? I made this multiple choice. Your answer might be one type, two types, 5 types, or numerous types. You know, I'll provide your answer. It is kind of a obscure subject as to how many modifications there are, because in my 29 years as a contracting officer with the Department of Defense, even my colleagues didn't even know the answer to this. So when I became chief of contracts, I would lay this on them every once in a while in a staff meeting, and over time, they all got it right. So what do we have for answers?
So it looks like it's pretty split.
Between?
Well, 5 and numerous both have 40% of the vote, and one person said 2.
Oh, and one person said 2. Okay. All right. So we'll provide that answer here shortly in the presentation. My next question is.
Oh, that is mean.
Yes?
That is mean.
Who has experienced a contract modification as a prime contractor or a subcontractor? There's 1, 2, Kelsey.
I have, yes.
Ryan. Good, this is good. So we'll have some class participation and probably lots of questions from at least those three people, their experience with contract modification, whatever type it was. Okay, let's get started then. Yes, our first technical difficulty, how to advance the slides.
Worked the other day. So you can either do it from your keyboard or on the screen. Move the cursor. It's hard to see in the bottom.
Yep. There we go. Okay, we'll do it that way. All right, our agenda for today is to learn the types of modifications. We'll get into change orders, terminations, the Christian doctrine, which a lot of people don't know about, stop work orders, your rights and remedies, and the difference between an REA and a claim. An REA is request for equitable adjustment, and at the end, we'll open it up to questions and answers. So here's some abbreviations, terms, and acronyms that we'll be discussing today, and probably many more. I want to go down the list briefly. B&O tax. The state of Washington is one of only 8 states in the United States that levies a B&O tax on the work that you do. And you have to realize that when you put your price proposal together, B&O tax is added to the very bottom subtotal, because the state of Washington gets federal contracts, the rate is 0.00484, and that is added to the very bottom line value of your contract or your modification, and that you're going to pay the state. So you got to be mindful of that. A lot of companies miss that in putting their price proposal together, which we'll address in my next class next year. The next 3 are indirect costs. There's field office overhead. That's an example. It's common in construction where you have to set up an on-site, typically trailer office to manage the work going on there. So that's field office overhead, which is different than G&A and home office overhead. Some companies combine G&A and home office overhead into one. Other companies separate them, but they are both your indirect costs. The next 3 are different types of solicitations. There's invitation for bid, which is seal bidding. And I provide there at the end the Federal Acquisition Regulation part where you can learn more about those. So IFBs are in part 14. RFPs, request for proposals, are in part 15. And RFQ, it's a request for quotation, is in part 8. So typically an RFQ is a solicitation that's issued under the simplified acquisition threshold, which currently is $250,000. And if you're able to decipher a solicitation number, you'll see a Q in there. In the solicitation number, it'll be the 5th position from the far right, to be a Q. That's an RFQ. And that sends a signal to you that the government believes that the value of this resulting purchase order is going to be less than $250,000. And if you see an R in there, that is a request for proposal. So that sends a signal that the government believes that the price of the contract is going to exceed $250,000. So if you decipher the solicitation numbers, that would be helpful for you also. Next in red is PDQQ. We're going to come back to that. I think that's really important. Next is DO and TO. DO is delivery orders and TO is task orders, and there is a difference between them. And it's defined in Federal Acquisition Regulation Part 2. Part 2 is definitions of terms. A delivery order is a delivery of a supply. That's the delivery. That's a delivery order. So on supply contracts, the orders are called delivery orders. TO is a task order. That's where the government is issuing an order for a task. So that is on a service contract. So task orders are on service contracts and delivery orders are on supply contracts. PO is a purchase order. So we know already that those are issued when the value of the, well, if the solicitation was issued as an RFQ on a standard form 18, then the resulting contract is a purchase order. And you can learn more about those in FAR Part 13. Often you'll hear about in scope and out of scope. In scope is a requirement that is within the scope of the contract, and out of scope is not in the scope of the contract. An example of that would be, let's talk about a contract was awarded for the construction of a building. After award, the contracting officer issues you a request for proposal for the construction of a 2-story parking garage right next to the building for the employees to park their cars. That is out of scope. The scope of the contract is to build a building, not build a building and a parking garage. That parking garage is out of scope. So you, as the recipient of that request for proposal, should challenge that. Certainly you don't want to turn down work, but maybe you don't have the capability or capacity to build a parking garage next to the building that you're constructing for the agency. So, you know, you consult with your attorney and decide how you want to proceed. But that is an example of out of scope. In scope, you have a contract to provide 100 widgets, and the government wants another 20. The ruling has been in the past that increasing a quantity of more than 25% is typically out of scope. If it's less than 25%, it is determined to be within scope. So in this case, you had a contract for 100 widgets and the government wants additional 20. That's only a 20% increase. So that would probably be determined to be within scope, in scope. The last two on there are terminations. Abbreviations that we use in the government is T for C and T for D. T for C is termination for convenience, and the other is termination for default. We'll be discussing those. You can find information on both of those in the Federal Acquisition Regulation Part 49. And I'm talking about all these parts. So my thought just came up is maybe a lot of people don't know how many parts there are to the Federal Acquisition Regulation. There are 53. And in my 29 years of experience, I probably only touched half of them. That's there. You can spend a whole career and not deal with all the parts of the Federal Acquisition Regulation. Good reading at night, though, to put you to sleep. All right, background. Here's your answer to the first question. There are two types of contract modifications. So whoever that was out there, congratulations, you got it right. They are bilateral and unilateral, and you can find information on those in FAR Part 43. Bilateral is when both parties agree to the change and both parties sign the contract modification. That is a bilateral modification. Unilateral is when the agency issues a modification with only their signature on it. It's not a meeting of the minds. It's not agreement between you and the agency. The agency is issuing it unilaterally. Sometimes they have the right to do that, or sometimes it's because it's urgent and compelling. The modifications are issued on a standard form 30. That's the same form where amendments to solicitations are issued also on a standard form 30. Any questions so far? I need to take a break here to answer any burning questions before we move on. All right. Background on modifications. So before award, during the solicitation phase, most solicitations are in a competitive environment, meaning the solicitation was issued to the population and it was open for any and all companies to submit a proposal or a quote. So in that case, you are submitting a price proposal. And a price proposal is a single price that includes everything: your direct expenses, your indirect expenses, your profit, B&O taxes, if you're in the state of Washington or one of the other 7 states. So that is a price proposal. All you're submitting is a single price for everything that's in the statement of work. After award, you are in a sole source environment where it's just you, the awardee, and the federal agency. And in that case, you'll have to submit a cost proposal. So there's a difference. You want to have your terminology correct. Price proposals and cost proposals. And a cost proposal may be subject to a third-party audit. Defense Contract Audit Agency may come in and audit your books to determine that you're submitting fair and reasonable prices, or just auditing your indirect expenses, which is your G&A or your home office overhead, whatever you want to call it. So an example of a cost proposal is identifying your labor, materials, equipment, insurance, bonds, your indirect costs, your greed factor, also known as profit rate, and taxes. So these are some examples that would be in a cost proposal. Realize you're going through this exercise anyway prior to award when you put a price proposal together. But after award, you are now having to submit all of that information in a cost proposal, which is subject to an audit. Any questions on that? Okay, next, modifications. You find this in FAR Part 43. This information came directly out of the FAR, out of the Federal Acquisition Regulation. I'm putting it here for you. And we want to review subparagraphs A and B. Paragraph A, only the contracting officer acting within the scope of their authority, also known as their warrant. So there's a difference between a contract specialist and a contracting officer. Both are contract specialists, but the one with a warrant is a contracting officer. So you need to know that. So typically when a contract is awarded, there's a kickoff meeting, a pre-performance conference. Different agencies call them different things. And it depends on if it's a service contract or a construction contract, what they're going to call it. But in there should be discussion about who has authority to do what. And the contracting officer should be identifying to you, the contractor, what their authority is. Authority could be the type of contract that they have authority to administer, like a service contract or a construction contract or a supply contract, so on and so forth. Associated with that is their dollar value that they have authority to execute modifications less than that amount. So an individual a contracting officer will have a warrant, say, for service contracts up to $1 million. So if you're doing a modification after award and it's $1.5 million, that agency's contracting officer does not have the authority to enter into negotiations and even sign the mod when there is an agreement. So it's really important to understand authority. That works both ways. On the other side of the table, at the beginning of the contract, the contractor is to submit to the contracting officer who has authority in your organization to negotiate a change to the contract and any dollar limitations. So it works both ways, both sides of the table. You need to know the person across the table who you are negotiating with has the authority to negotiate for the changes and the dollar amount that we're talking about for this instant modification. Otherwise, there's no point in having the conversations. So I, as a contracting officer, when I entered into negotiations, one of my first questions was, who has the authority, or do you have the authority to negotiate this? If you don't, meeting adjourned. Go get the person who has the authority. I'm wasting my time. Empowered to execute contract modifications on behalf of the government. Other government personnel should not execute a modification. So if they don't have a warrant and they are not working within their warrant, they don't have the authority to sign a modification. Act in a manner as to cause the contractor to believe. Okay, so a good example of this is overseas. I spent half of my career in overseas positions. One of three was in Japan, the second one was in Cuba, and the third one was in Italy. What happens quite often in overseas environments is the local nationals, so in the case when I was working in Japan, the Japanese contractors are doing work, and when a military person in a uniform and a hat and brass on their shoulders walks up to them and says, "Oh, can you do this and do that?" Well, that officer, they perceive that officer to have the authority. You know, he's the U.S. military. He's in a uniform. I guess I better do what he says. So that happens regularly. So those end up being unauthorized commitments. And that's when the Japanese laborer, the Japanese supervisor tells his Japanese coworkers, "Oh, so-and-so just said to go do that, so we're going to go do that." And then a month or some months later, they submit their monthly invoice, and it included that change. And the contracting officer are looking at this invoice and saying, "I didn't authorize that." They're on the phone and we're talking about this. "Who told you to do that?" So now they got to process an unauthorized commitment. If the government got a benefit out of it, the government's going to pay, but now we got to go through. It's going to go all the way up to the commanding officer. All kinds of people get involved. Got to go get the money, pay the good man. And typically there's repercussions to that individual, in this case, that identified as the officer who went on this Japanese construction work site in his uniform and directed the Japanese contractor to do something. He's going to have repercussions because he did not have the authority to do that. And subparagraph 3, the director encouraged the contractor to perform work that should have been subject of a contract modification. So in that scenario that I just laid out, that Japanese site superintendent, project manager, whatever, if he suspected that this U.S. government employees told him to do something, and he says, "I don't think that's in the contract," his course of action should have been to call the contracting officer and ask them, "Hey, so-and-so just told me to do this. Do you want me to do that? I think that's out of scope, or it's in scope, but it's additional work. So we need to get this forward price and issue a modification to get this in the contract, and then I'll do it." Okay. Okay, subparagraph B, contract modifications, including changes that could be issued unilaterally, shall be priced before the execution, if this can be done without adversely affecting the interest of the government. If a significant cost increase could result from the contract modification and time does not permit negotiation of price, at least a ceiling price should be negotiated unless impractical. So there's a lot of information in there, lots of different scenarios. So basically what they're saying here is, if the government should always enter into a bilateral modification when time is of the essence, it's urgent and compelling, the federal agency can issue a unilateral modification. But what they should be doing, what this paragraph talks about, there should be at least a ceiling price that's issued in that modification. If the government thinks it's going to cost about $30,000, they'll have a discussion with the contractor. Hey, we got this urgent change. Here's what we're thinking the scope is. What do you think the not to exceed amount may be? They may come to an agreement of, say, $35,000. Okay, so the federal agency then issues that unilateral modification because they don't have time to pre-price it, forward price it, and putting a line of accounting on there for not to exceed $35,000. Issue it to the contractor. The contractor then starts work, because he has to, and puts a proposal together for that scope of work for that change, submit it, get it negotiated during performance. A bilateral modification is then issued with the agreed upon terms and conditions and price, and the contractor signs it, then the government signs it, and distribution is made to the contractor and any number of other parties. So it started out as a unilateral modification and it ended up in a bilateral modification. Any questions on that? There are a lot of different nuances on that. Okay, moving on. Proposals for modifications. This is important. Your proposal is only for the proposed change. It is not an opportunity for you to get well because you underpriced the original contract award amount. Or because, hey, I'm in a sole source situation now. I can ask for anything I want because it's just me and the government. Question out there? Michael? Okay. So because you think you're in a sole source situation, or actually you are in a sole source situation, you can now dictate your price. Well, that's not the case. You can only put a proposal together for the proposed change of work. And something that we haven't talked about and it's not in here is contingencies. So when you, and this is unique to federal contracting, when you put your original proposal and you competed for the award of the contract, that proposal, that price that you submitted, whether it was a price proposal or a cost proposal, is not to have any contingency pricing in it. In private industry, that's the norm. You put contingency money in your proposal to get the contract. In federal contracting, you don't do that. The reason for that is you're only putting a price in for the scope of work at hand. What the government will do is anytime that there's a change that's needed after award, they'll enter into a negotiation for that change, get your terms and prices, and issue a modification to increase or decrease the value of the contract. So changes are priced as you perform the contract. Last bullet there is important also. When you put your cost proposal together for a modification, make sure that you put in how long your proposal is valid. Been lots of examples of this over the years. And right now we're in a pandemic and there is a problem with the supply chain. So things can be taking longer and prices are going up on lots of different commodities. So when you go out and get your pricing information from your suppliers and vendors, ask how long that price is good for and put that in your proposal also. You know, may be good for 30 days, may be good for 90 days. We'll put that in there. And so that puts the onus on the government then to act quickly, because if you go beyond that date, your price may change, but you also don't have to sign the modification because your price proposal is only good for 90 days and it is now 110 days. I need to submit a new, or I need to validate my cost proposal that I submitted to you. Go out and check your vendors and suppliers, have the changes, have the prices for concrete, lumber, widgets, computers changed, and submit your revised price, and it's good for 45 days, whatever. Okay, questions on that? Next slide. Bilateral modifications. So the next 4 slides, we're going to discuss bilateral modifications and unilateral modifications. Bilateral modifications is discussed in part 43. So normally a request for proposal is issued. You submit a cost proposal. You negotiate a fair and reasonable price and or terms. And the agency provides a modification for you to sign first, and then you submit it back to the federal agency and then they sign it. It is always the contractor who signs first, and then the federal agency signs second. And then the agency makes distribution to you and others. So when you sign a modification, you will typically see a paragraph in that modification that's called a release of claims. So when you sign that modification, the government signs it, they make distribution, you've lost your right to come back and reprice that because you made a mistake, whatever. That is a release of claims, meaning that you cannot request an equitable adjustment or submit a claim for the same change that we just negotiated and executed a bilateral modification. So some examples of bilateral modifications. you've negotiated an equitable adjustment resulting from the issuance of a change order. That's a bilateral modification. Definitizing a letter contract. So a letter contract is normally issued unilaterally, and it's an undefinitized action. It results in definitizing that action because after the letter contract was issued, you submitted a proposal, you negotiated a price, and then they definitize that letter contract. And lastly, reflects other agreements of the parties. So often I and other contracting officers have issued modification that says agreement by the parties. So we've changed some terms and conditions in the contract. There was no particular clause that gave us that right to do that, but we had a meeting of the minds. We are both going to sign the modification. And so that's another time for a bilateral modification. Next page, examples of bilateral modifications. Delivery schedule acceleration, quantity increase or decrease, quality increase or decrease, adding or deleting clauses, and changing any other terms of the contract. You have to have a meeting of the minds. Modification is issued, the contractor signs it, goes back to the federal agency, contracting officer signs it. We now have a bilateral modification for this change. I need to make a mental note and go back to our one of our first pages where I had in red PDQQ. We need to talk about that. This brought it to my attention again. PDQQ. So in my 29 years at the very beginning, lots of classes I had to go to. One of the instructors talked about PDQQ. And this is a good place to talk about it because it addresses when a bilateral modification is required. Price, delivery, quantity, or quality. If the change affects any one of those four, a bilateral modification is required. Price, a proposed price change, proposed delivery change. We talked about here, delivery schedule acceleration. Quantity, increase or decrease in quantity, bilateral modification. Quality, if they wanted chrome and the government changed their mind and they want gold, that's a change in quality. It can work both ways. They issued the solicitation and awarded a contract for gold, and during performance, the government's changed their mind. They only need chrome. So that's a decrease in quality. It's bilateral modification, PDQQ, price, delivery, quantity, quality. I use that for the rest of my career as a contracting officer. Really useful. Never forgot it, as you can tell. All right, let's talk about unilateral modifications now. It's in part 43. The agency does not have time to negotiate a change. So it's something that's urgent and compelling. We got to get it done now. And a good example is the pandemic. The virus clause that just came out a few months ago, and all the agencies had to modify it into their contracts. We'll talk more about that. So the government issues a unilateral modification with only the agency's signature on it, the contracting officer, via the changes clause. So your right to submit a timely request for equitable adjustment is in accordance with the clause. You negotiate a fair and reasonable price and or terms, and then the agency issues a bilateral modification for both parties to sign. So it was initiated because of the urgency as a unilateral modification, ends up as a bilateral modification after you submit your proposal for that change, arrive at a fair and reasonable price. The bilateral modification is then issued. Bullet 2 there, the contract has one or more options in it that the agency may exercise. These are done so unilaterally in accordance with the terms of the contract. So what we're talking about here is options. And there are basically two different types of options that the government can exercise unilaterally. So one is a contract is awarded for a specific period of time, but it has multiple CLINs in it. Those are contract line item numbers. So the basic contract was CLIN 1, and then there may be one or more additional line items that are options that the government can exercise if they so choose to. First, they got to have a need, they got to have the money for it, and they got to do it within the specified time that's in the contract terms and conditions. So each one of those may say that, for example, CLIN 2, option number 1, can be exercised within 60 days after contract award. That's just an example, but normally that's in there. And CLIN 3, which is option number 2, can be exercised anytime during the performance of the contract. So if the government needs number 1, but they've gone beyond that period of time that's in that CLIN, option 1 of 90 days, and they're out there, 6 months into the contract performance, and now they decide they want it, you don't have to accept it. Chances are, though, they're going to have a discussion with you, and you're not going to typically turn down work, but there are occasions when you might, and you come into an agreement, but the price might have changed, or the terms might change. So work out an agreement, come up with a meeting of the minds, and issue a modification with the new terms and conditions and price, whatnot. So that's an example where there are options within a performance period. Another type of option is what we sometimes call a multi-year contract. So take the example of a janitorial service contract. It's issued for a base period of 12 months, and it has 4 one-year follow-on option periods for a maximum total of 5 years. The government towards the end of the current 12-month period can exercise their option of exercising the next option in the contract for the next 12-month period. So that is an option where they will do that every 12 months to get the full value or full term of the contract out to 5 years. They have to satisfy 4 things, though. There's still a need. They have the money. The contractor's performing satisfactorily, and a 4th item. So those are the 2 scenarios for options that the government has a unilateral right to exercise those options because they are in the terms of the contract, and provided that they exercise their right within the terms of the contract. Some examples of unilateral modifications: make administrative changes, issue change orders, make changes authorized by the clauses that are in the contract, such as government property, options clause like we just talked about, suspension of work, which we will be talking about, and 4th, the issuance of a termination, whether it's termination for convenience or termination for default, and we'll be talking about those also. Any questions on unilateral modifications? Here's some examples, more examples of unilateral modifications. They could be for the exercise of a next term of the contract, which we just talked about, exercise of an option within the term of the contract that we talked about, termination for convenience, termination for default, correcting a line of accounting. The line of accounting you're indifferent to, but on the government side, they got to get their line of accounting correct. Maybe they had a typo in there, so on and so forth. So they can correct that line of accounting with a unilateral modification. A price reduction for no work or poor work. An example would be a grounds maintenance contract, where you are to cut the grass, maintain it within so many inches, weed-free. And so you have to cut that grass every so many weeks during the growing season, and in the off season, maybe once a month. But if you did a poor job in doing that, the government can do a deduction for poor work. If you missed a lawn mowing that's in the contract that should have been performed, that would be a deduction for non-performance. Either way, the government has that unilateral right to do a price reduction in your contract. And lastly, other administrative changes. They're administrative in nature, no effect to PDQQ, price, delivery, quantity, quality. It's just an administrative change. Change orders. So this is a type of unilateral modification that we talked about, is a change order. It comes out of FAR Part 43, and the subparagraphs A, B, and C came right out of the Federal Acquisition Regulation. I didn't make any changes to this. So subparagraph A, the government contracts contains the changes clause in it that permits the contracting officer to make a unilateral change in the designated areas within the contract, the general scope of the contract. Here we're talking about in-scope changes versus out-of-scope changes. The contracting officer cannot issue a unilateral change order for a change that is out of the scope of the contract. So the example I gave earlier was you have a contract to build a building, and now the contracting officer wants to issue a change order for you to build a 2-story parking garage right next to it for all the employees in that building. That is not within the scope of the contract. They cannot issue that change order. You may issue it, but it's out of scope. You don't need to respond to it. And so these change orders are accomplished by issuing a written change order on a standard form 30, which is the same form that we used for amendments to solicitations, or else otherwise provided in the FAR Part 43. Subparagraph B, the contractor, and this is important, when you get a change order, you must perform it. And during the performance is when you are going to prepare your cost proposal and submit it and negotiate a fair and reasonable price. And then it's followed up with a bilateral modification where you sign it and they sign it and it gets distributed to everybody. So then it's within the scope of the contract, that additional work or the change work. Changes can be additions or deletions. Subparagraph C, contracting officer may issue the change order electronically or verbally. I have issued verbal contract modifications in my career. The requirement is, though, you're supposed to follow it up in writing within 3 work days. So the reason why we do it via email or verbally is because of the urgency of it. It's probably a good time to use the example of the clause. What we got here? Change, move. Because of the pandemic, there was a clause that was created for all workers on federal contracts to be vaccinated. I'm sure you're probably quite aware of that. And over the past few months, we've had clients with lots of questions on that because different agencies handled that direction in different ways. So we know that there was one federal agency that sent a bilateral modification to their contractors and said, you need to sign this and get it back to me within X number of days, or you lose your right to submit invoices and so on and so forth. It's like a threat. It should not have been handled that way. Of course, I don't know what the direction from on high was to those agencies and their contracting officers, but in general, if something was urgent like that, and you're not giving the contractor an opportunity to price it, it should be, which would be a bilateral modification, which is what the agency sent in this case to the contractor and say, hey, sign this. This is the new clause for the pandemic that you need to sign and assure us that all your employees are vaccinated. The agency should have been issuing that unilaterally because of the urgency that it had to be put in their contracts. So sending a unilateral modification, incorporating that new clause into their contract, gives the opportunity to the contractor to put a cost proposal together for any proposed terms and condition changes or pricing. Maybe it's going to cost the contractor more to implement this change for his employees to get vaccinated. As we know, a number of employees didn't want to get the vaccination, so the contractor is going to have to deal with that, reassigning them or replacing them, firing them. The proper course would have been to issue a unilateral modification. The contractor starts performing that, but is given an opportunity then to submit a cost proposal for that change, which would result in a bilateral modification. All right, where are we at here? On B, must continue performance with some exceptions, cost reimbursement contracts or incrementally funded contracts. Subparagraph C, the contracting officer may issue a change order by electronic means. This is what we talked about. It can be via email or a phone call. I've made phone calls to my contractors, and essentially what I tell them in the email or over the phone is the same information that would appear in the contract modification on the standard form 30. You know, what's the scope, what's the duration, so on and so forth. I've added under subparagraph C 2 additional bits of information. This is really important that if you receive a change order, you need to start recording your expenses for that proposed change, because eventually you're going to enter into negotiations or discussions for a fair, reasonable price. Well, if you come into that meeting with the contracting officer with no actual expenses to that date, you don't have a leg to stand on. So once you get a change order in your accounting system, start recording your changes as a result of that proposed change in that change order. And you have that documentation that you go into discussions with the contracting officer. You'll have greater success in supporting your argument for the prices that you want. Last, the clause states that you must assert your right for an adjustment under the clause within 30 days from the date that you receive the change order. This is important. When you receive a change order, it's going to have a scope of work for that change. And when you read through that, of course, you're going to start performing it, but you're going to read through that and decide what's the impact on you. Is it going to affect your price? Does it affect, yeah, you say, yeah, it does, but does it affect it enough for you to go through the expenditure of your resources to putting a cost proposal together, sending it to the contracting officer, negotiating it, and signing a bilateral modification? That's a business decision that you need to make. But if you decide that you are going to pursue submitting a proposal, according to this and according to the clause, it's in the clause, you must notify the contracting officer within 30 days that you plan to do so. Doesn't mean you got to submit your proposal within 30 days. You, at a minimum, have to notify the contracting officer that you intend to submit a proposal for this change order. Any questions on that? Terminations. Okay. We're coming towards the end. Terminations, 2 types. First one, termination for convenience. This is when the government needs to terminate the contract for any number of reasons. This is not your fault. This is an action on the part of the government. You will want to submit a request for equitable adjustment for all your incurred costs to the date of the termination, and any other costs you will incur that you cannot avoid. The example of that is you had to recarpet an entire floor of a building. Well, you had to go out and select that carpet, got approved by the government. Yep, that's the kind we want. It's nylon, it's that color, it's that quality, a pad underneath the carpet. And you had to order it for installation some point downstream. The government terminates that contract for convenience for whatever reason. The new commanding officer has changed his mind, or the new one says, I don't want that, or they don't like the color, or they no longer have the money, it was withdrawn. There's all kinds of reasons for the government for terminating for convenience. So in this case, what I wanted to talk about here is you are to stop incurring costs up through to the date of that termination for convenience modification that was issued to you. But this further goes on and says, and any other costs you will incur that you cannot avoid. So the example I was giving here was you ordered the carpet, it's coming in the future. You call the vendor. Yeah, you can cancel it, but there's going to be a restocking fee. So that is a cost that you're going to incur that you can't avoid that's coming later. You can include that in your cost proposal for a settlement of a termination for convenience. The other type of termination is termination for default. This is when the government terminates the contract due to something you did. Poor performance, something unethical, unlawful. Your quality is poor and it's not going to get improved. You have a strike that you didn't provide more people, the replacement people, and all kinds of reasons why the government can terminate. This is your fault. And as a result, you may have to pay for the re-procurement of the replacement contract. So they're terminating your contract for default because of something you did, but the government still needs this to get accomplished. So they're going to go out and resolicit, get a new contractor come in, and all of that effort, that cost of that effort will be charged to your company. So you get double whammy on that. Avoid terminations for default. And also a contractor's performance evaluation will be issued too. And that will go out and get recorded in PEPRs, and all federal agencies have access to that. And chances are you will not get another contract for another 5 years. So customer service is good, or is required after contract award. The Christian doctrine. Federal acquisition regulation does not address this, but is something that a contracting officer learns, and many contractors learn the hard way. So since 1963, the courts have held that certain clauses are so integral to the public procurement process that they are deemed incorporated by operation of law, even if they are omitted in the contract. So there are many clauses, and so one that comes to mind is a service contract that exceeds $2,000 in value is required to have the Department of Labor wage determination provided in the solicitation and the follow-on contract. Often, contracting officers forget to put it in. In fact, I had a client a couple of months ago who he and I reviewed a solicitation. It was a service contract, very expensive, and it was missing the Department of Labor wage decision. So in that case, during the solicitation phase, the contractor should be submitting a PPI, a pre-proposal inquiry, to the contracting officer and saying something to the effect, this is a service contract, it's over this dollar threshold. Should there be a Department of Labor wage determination in here? And what the contracting officer will do, the light bulb will go on is, oh yeah, I forgot to put that in there. And it's going to issue an amendment on a standard form 30 and providing the Department of Labor wage determination. And that requires all the potential offerers to put their price proposal or the cost proposal together using the Department of Labor's wage determination for blue collar workers. These are the guys that are swinging the hammers: electricians, plumbers, welders, whatever, secretaries, AutoCAD operators, truck drivers. This goes on and on and on. It says in the wage determination what is the minimum amount to pay that employee plus fringe benefits. And that doesn't mean that that is what you have to pay them. That means that you cannot pay them anything less than that. You can pay them more, but you can't pay them less. Now, the other nuance to this is, okay, the contracting officer put the Department of Labor wage determination in the solicitation in the follow-on contract, but he put the wrong one in there. So the courts have ruled that it is the responsibility of the contractor, not the federal agency's contracting officer, to make sure that the correct wage determination is in the contract. It's gone to court a number of times and always has ruled against the contractor. When a service contract, for example, is issued and had a wage determination in it, but it was the wrong one. It was for a different state, different county, different type of work, whatever. The contractor is responsible for knowing the correct wage determination and paying in accordance with the correct wage determination. So this applies to many clauses. If the FAR states that it is a required clause, then it is part of the contract, even if the contracting officer omitted it. For example, termination for convenience, termination for default. It's required to be in every contract. The changes clause is required to be in every contract. If the contract is issued without it, you've got to proceed like it was in there. Of course, you can always bring it to their attention, and the contracting officer may modify the contract or modify the solicitation. Hey, you're missing this clause. Bring it to their attention. They are human. They make mistakes. I did also. And early on, I would issue a solicitation. I'd go running into my supervisor's office and say, hey, boss, I made a mistake. I did this. And he said, relax, be patient. That's why standard form 30s were created. You can issue an amendment to the solicitation. Or after a contract award, don't worry, we issue a standard form 30, a modification to the contract. There's nothing that can't be fixed. Any questions on the Christian doctrine? Next, stop work orders versus suspension of work. They are essentially the same. The difference is the terminology. Stop work orders applies to service contracts, supply contracts, and research and development contracts. The clause is FAR 52.242-15. The order may be, so once the stop work order is issued, it can be canceled, it can be extended, it can expire, or the government can terminate the work that they issued a stop work order on. Realize if you don't get any guidance from the contracting officer. So typically a stop work order is issued and says stop work for 30 days. When 30 days, the 30th day approaches, the contracting officer can cancel that stop work order and you go back to work. Or the contracting officer can extend it. So the 30 days has come and it's about to go, and so, I need to extend the stop work. You need to stop work we're going to extend this for another 30 days. Or during that 30-day period, the government decides to terminate that work that they had you stop work on. And then, of course, you're going to be asked for a proposal, a cost proposal, to price out that work that is going to be terminated, and gets negotiated a fair and reasonable price, and a bilateral modification is issued, and then you continue working on the rest of the contract. And the fourth situation is that 30 days comes and goes. It has expired. In that case, you can go back to work. You have no guidance from the contracting officer. That 30 days has come and gone. You can go back to work. Realize that when a stop work order is issued, you can submit a request for equitable adjustment for any costs that you incurred as a result of the government stopping work on you. The other is called a suspension of work. That applies to construction and architect engineering contracts. And that is found in FAR 52.242-14. Essentially, it's the same things apply, can be canceled, extended, expire, or terminate some portion of work. And you can submit a request for equitable adjustment for any costs that you have incurred as a result of that suspension of work being issued to you. Any questions on stop work orders or suspensions of work? Okay, next is rights and remedies. You all should have this one-page handout. It's a table of clauses that you may find in your contract. You want to be familiar with these. These are just some. These are examples of clauses that may appear in a construction contract. A number of these can appear in service contracts, architect engineering contracts, any number of types of contracts. So looking down that page, we can see first off is the changes clause. Next one is differing site conditions, default clause. It's termination for default, suspension of work, inspection, use and possession prior to completion. That's where the government, during the performance of the contract, may want to take possession or use of what you are providing to the government. Take possession or use of it early. Time extensions and government property. So reading across that table, it provides the clause where you can look that up. And it talks about whether what your remedies are, direct costs, overheads, profit, acceleration, time, liquidated damage adjustments. And there's an X in the box if those conditions apply to that particular clause, or it will say none, it does not apply to that clause. So sometimes you have a choice. Anytime you submit a request for equitable adjustment, you have to cite in your request which clause you're submitting your request for equitable adjustment under. If it's not one of these, it's another one in your contract. You need to cite the clause. Otherwise, your request for equitable adjustment can be rejected and sent back to you. I have a lot of experience with that. Contractors submitting a request for equitable adjustment and not citing the clause for which they're seeking relief under. So in some situations, you may have a choice of more than one of these clauses, but you need to select one. And this table can help you because you can see that in some cases, you can get relief for your liquidated damages, or you can submit profit, or some clauses you can't submit profit. So this is a useful table that can help you decide which clause you want to submit a request for equitable adjustment under. Any questions on that? All right. REAs versus claims. We're on the last slide. A request for equitable adjustment. You are working in partnership with the contracting officer to arrive at an equitable adjustment for a changed condition. You can learn more about this in FAR Part 43.204. So you're still in a partnership with the agency. There's a change. Either you've identified it or they've identified it. You've submitted a request for equitable adjustment as a result of that change. You're trying to arrive mutually agreeable for a fair and reasonable price that will be followed up with a bilateral modification where both parties sign it. A claim, on the other hand, is an adversarial relationship with the agency because you do not agree with the terms that the agency is dictating to you. You're at an impasse in negotiations. You can't reach a meeting of the minds of a request for equitable adjustment. They've done something to you for which they're not going to correct, don't want to correct. You believe you are right, they are wrong. So now the attorneys are involved. Your attorney is involved, the agency's attorney is involved. You're in an adversarial relationship. You can learn more about this in FAR Part 33. So remember that when you are awarded the contract, you are part of a team. There is the contracting officer, the contracting officer's technical representative. There's the end user that has the need. That's why we're in this contract now. And there is you, the prime contractor, and your subcontractors, if you have any. It is a team effort. Everyone is working together for the end goal of completing this contract successfully, on time, with quality. And as a result, you'll end up with a contractor's performance evaluation that is at least satisfactory or better. You're always working for that performance evaluation because those can haunt you for 5 years or more. So it's after award is all about customer satisfaction, meeting the terms and conditions of the contract on time with quality, and getting a performance evaluation that you can address in future proposals and market your company to other federal agencies that you have experience with this agency, you've got an outstanding or above satisfactory, whatever. So it's really important to strive to get that at least a satisfactory performance evaluation. Any questions on REAs versus claims? All right, we're opening this up to questions now. Questions and answers. I didn't get many during the presentation. Do we have any now? And after this, I'll close with a summary.
Any questions, folks? There's nothing in the chat, so just unmute yourselves if you have a question for Terry. He is a wealth of knowledge on this stuff, and I confess I felt like I was a bit with my head underwater on this, but that's why you need to ask the questions. So any questions out there?
So I know at least 3 of you have experience in contract modifications. If anybody can talk about their experience, the type of modifications that they went through, type of contract that they were on, service contract, supply contract, construction contract.
So
yes, go ahead.
I do have a question. I didn't see you put in your slides no cost extensions, which we're familiar with, and actually, as far as I'm concerned, have worked pretty well for us. So those appear to be unilateral to me because, well, I guess we request them, but we're not asked to sign anything. I mean, basically, the contracting officer sends back a document that says, okay, we'll give you 2 more months, or we'll give you 6 more months to complete the work. And, based on the original bid, that's been fine with us. So, that's been unilateral. But then I guess my question is, in some cases, we, let's say, reach the end of the contract period and our TPOC, I think it is, technical point of contact who we're working with, says, well, geez, can we finish up this piece of work? It'll go over, or they don't even bring it up, right? That the time period is going to go over the contract. But we say, okay, fine, we'll do the work and we'll submit this, even though it goes beyond the defined contract end. How important is that? Because my understanding is that it's actually a fair bit of, maybe it's not, but my understanding is it's kind of a fair bit of work to try and get them to extend something by, let's say, a month to, in all the documentation. How important is it to have that paperwork?
So let me understand completely your scenario is that towards the end of the performance period,
yep,
you're completing your work within the contract performance period,
right,
but the contracting officer's technical representative is come on site prior, a few days, few weeks, a month before the end of the contract and that's asking for something in addition. Is that what you're saying?
Really asking for something in addition, asking for something, you know, it was maybe not defined exactly. I mean, we're doing research and development, right? So we're trying to develop something. And then actually, it wasn't something that he asked for. Let me be clear about that. He didn't say, and he did not come on site. We were talking on the phone. So he said, well, you know, gee, if you did that, that would be interesting. And so we said, okay, we'll offer to send that to you. But, you know, of course, I know in my mind, it's going to take beyond, you know, it's going to take us beyond the end of the contract, which we will actually willingly do in this particular case.
Sure.
But-
Typically, contractors won't turn down additional work.
Yeah, well, and it's just kind of fulfilling the agreement that we, you know, that we started with. So we're not, you know, we're not trying to hold anybody's feet to the fire, but I guess the thought went through my head, and part of the reason my signing up for this was like, okay, you know, how critical is that for us to, you know, because when they've gone through, and this TPOC has gone through getting us no cost extensions in the past, but it, my God, it seems like, I mean, I would have thought that that was easy, but it almost seemed like it was like pulling teeth or something, you know, but we got it done. But in something that sort of seems small, how important is it to have that, you know, that paperwork trail completed?
Very important. It could haunt you in a number of different ways. So the first thing under that scenario is you should have been, after that conversation with that technical person, been in communication with the contracting officer, because only the contracting officer, as we discussed earlier, can make any changes to a contract within their warrant.
Mm-hmm.
Okay. And in this case, was there additional expense for your company to do this?
I would
Would
say
it-
time, I guess, you know, I mean,
Right. Okay. So no additional cost, but additional time. And in this case, you would want the contracting officer to issue a bilateral modification. You know, if there's no cost, no other conditions that are involved here, that the contracting officer would issue a bilateral modification to you once you and he or she have agreed to how much more time you would need to do this, and put it in a modification that the contract completion date is hereby extended by X number of days to this new date. You want that in a modification to protect you in the future. If for no other reason, your contract performance evaluation was going to say, one of the elements is, did they complete the job on time?
Mhm.
Well, if you didn't have a contract modification that was extended out here and you completed it after, of course, you completed it after the original completion date, how is that evaluator going to answer that question? It's late.
Mhm.
That is one perfect example why you need that modification.
Mhm.
Both parties have agreed formally in a bilateral modification that the completion date has been extended by X number of days to this date to do this change, whatever. Yeah, very important.
Okay.
And it should be no skin off the nose of the contracting officer. You know, I know they are overworked. There is a lack of them. There is a great lack of contract specialists in the federal agencies. Has been for years. They are hard to recruit, takes a long time to train them. And I just had a conversation with a client yesterday where we hire them out of college typically. We train them like 52 weeks of training, all these classes they got to go to, and then private industry steals them away because private industries pays them twice as much as what a contracting officer working for a federal agency as a civil servant gets. And then the cycle starts again. We got to hire more college students, train them, and they get stolen by private industry. We train them and they get them. So that's one thing that contracting officers are always thinking about. Oh, my workload, my in basket is piled up. Oh, now I got another contract mod to do, but it's in your best interest to get that executed.
Yeah, they definitely tell you about that.
Do they?
Yeah.
I don't have time for this. I'm sorry. We need to do this. Otherwise, I'm not obligated to do this work. I can't do it without the time extension, really.
Yeah, and in this particular case, to be absolutely fair, you know, to the TPOC, I mean, we volunteered it, right? I mean, actually, I hear your words, absolutely, but it was one of the things where we had completed what was due. Okay, so I don't think we're going to be evaluated negatively because we were told we were to complete some plates and we completed that and we sent that in and we said, oh, you know, it occurred to us that we could make better plates if we did this a little differently. And the guy said, well, I'd be interested in that. And I said, I tell you what, we'll make them and we'll send them to you. And, you know,
But it's going to take some time.
but it's going to take some time, right? But yeah, and they're going to test them and, you know, and tell us about that. But anyway, yeah, I hear your words. And just, you know, to be fair, we had completed the scope of work that was on there, that was in the agreement. So that's all, you know,
On time,
huh?
on time.
On time.
Right.
Yeah. So this was more of a case where we said, oh, if we made a different molecular weight, it might even do better. You know, I mean, we've read some, you know, some papers that look like they could, you know, like improvement in performance is possible. You know, are you interested? And they said, yeah. And we said, okay.
Issue me a no cost time extension.
Right. Yeah. So the no cost time extension would be even better. Yeah. I hear you loud and clear.
Okay.
Yeah. Thank
Very
you.
good. Very good subject. Thanks for bringing that up.
Yeah.
Anybody else with contract modification experience?
Yeah, we just had to do the COVID paperwork, and then they gave us 2 days. And
Yeah.
we didn't have enough time to contact our lawyers, and it was a project that we didn't really want to lose. And right now we don't have vaccinated workers in that area. So I let them know there could be cost impacts for travel pay to accrue workers. But my question is, like, since I only had 2 days and had to send it in, I sent it to our lawyers. It wasn't enough time for them to look at it. They're still reviewing it. So
That's the problem. So who is the agency, if I may ask?
It's Navy.
And did they issue it as a bilateral modification or unilateral?
Because we're a subcontractor.
Mhm.
It wasn't specific. It came from the prime.
Right.
So my question would be, because the time frame was so short and I was basically under the gun it basically said, like, either you need to walk away from the project or agree to it. Is there a way to modify the agreement if we find something that we'd like to modify?
If you sign the modification as a subcontractor to your prime contractor, you have given up your rights.
Yeah. Okay.
And that's why I talked about this in length earlier.
Yeah.
The agency submitted it to the prime contractor on a short fuse, couple of days. Here,
Yeah.
sign this bilateral modification and get it back to us. This is a mandatory clause. It has to be in the contract, and Congress or the White House, Department of Defense is saying it has to be in the contracts, all of our contracts that aren't exempt, by such and such a date. And so the contracting officers, the agencies and the contracting officers are under the gun to get this done. But it should not have been, in the case that you just identified, you're going to incur some additional costs because not all of your employees are vaccinated. So it should have been issued as a unilateral modification that's putting the clause in the contract. And then that gives you time to put a cost proposal together and submit for a request for equitable adjustment. That's how it should have been handled. Now, if they truly issued a bilateral modification and the prime contractor signed it and sent it back for the contracting officer to sign it, and they made distribution, they've lost their right, and all the subcontractors' rights, to submit a cost proposal for your incurred costs of losing employees who didn't want to get vaccinated, bringing them in, whatever additional costs there are, because you signed a bilateral mod, you've given up your right for a request for equitable adjustment in the future. That's why I think that whole process was wrong. GSA slammed it down their contractors' throat also a month or so ago.
Okay.
So it's interesting to learn. I knew GSA did it, and now you're telling me the Navy sent it too, but we don't know if it was unilateral or bilateral.
Right.
Because you're the subcontractor.
Right.
Yep. Good topic. Anybody else? Anybody without contract modification experience have follow-on questions? Or even off topic? Take advantage of me. I'm here. Okay. We will call it a day, Kathy. Thank you all for coming. I hope as I experienced when I went to lots of weeks of training in being a contracting officer, that any class I went to and I took away at least one new thing that I learned, the class was worth attending. Hopefully it was, in this case, you learned more than one thing.
All right. Thanks, Terry.
Thank you. Have a great day.
Thanks, Terry.